Alright, part 4, application and submission information. E. Funding restrictions. All proposed project costs must be necessary and reasonable in accordance with the federal guidelines. The determination of the allowable costs will be made in accordance with the cost principles now found with the Office of Management Budget Circular Uniform Administrative Requirement Cost Principle Auditing Requirements for Federal Grant Awards. Uniform Guidance codified in Title 2 CFR Part 200 and Title 2 CFR Part 29. Uniform Guidance Department of Labor Specific. Disallowed costs are those that charge with grant agencies to representatives determined not to be allowed in accordance with the cost principles of contained in the grant. Applicants, where successfully or not, will be entitled to the reimbursement. Applicants, whether they're successful or not, will not be entitled to reimbursement of pre-award costs. Indirect costs, the specified uniform guidance cost principles, and indirect costs, those incurred for common job objectives, cannot be readily identified with a particular final cost objective. The indirect costs are required when an organization operates under more than one grant or other activity with federal assistance or not. You have two options to claim the reimbursement of the indirect costs. Option 1, you use the negotiated indirect costs required agreement cost allocation plan supplied with the federal cognizant agency. If you don't have a negotiate indirect cost request agreement cost allocation plan with the NICR cap in the either choose of the independent choose to be included estimated the cost of the indirect in your budget with the time of award with the grant officer will release the funds amount with 10% of the modified total direct costs. See Department of Labor definition below. Support indirect costs within 90 days of the award. You are required to submit an applicable indirect cost proposal or a cost allocation plan for the federal cognizant agency to obtain provisional indirect cost rate. Section 4B4 for more information on the NICRA submission requirements. Title 2, Option 2. Any organization does not have a current no negotiated, including provisional rate with exemptions notified in Title 2's PR 200 414. F. The cost principles may elect to charge the de minimis rate of 10% modified total direct costs. See Department of Labor definition below, which may be used indefinitely if the chosen methodology ones elected must be consistently for all federal awards until such time as non-federal entity chooses to negotiate for a rate which the non-federal entity may apply to do any time. See Title 2 CFR Part 200 414F for more information on use of de minimis rate. Modified total direct cost definition. To avoid serious inaccuracy with the distribution and direct cost, the Department of Labor defines modified total direct cost as all direct salaries, wages, applicable fringe benefits, material supplies, services, travel up to first $25,000 of sub-award or contract, regardless of the period of performance, sub-award and subcontracts under the award. Modified total direct cost excludes equipment and capital expenditures charged for the patient care, rental costs, tuition and readmission, scholarship and fellowship, participation support costs, the portion of each sub-award or subcontract in excess of $25,000. Salary and bonus limitation. No funds appropriated under the heading of employee and training given the appropriate statute may use the recipient and sub-recipient of such funds to pay salary and bonus of the individual either as direct costs, indirect costs, or as a rate excessive with executive level 2. Limitations does not apply to contractor providing good services as defined in the audit requirements for the Office of Management Budget Uniform Guidance. See Title 2 Part 200 Subpart F, where states are recipients of such funds. States may establish a lower limit of salaries, bonus for the receiving salary, bonus for the sub-recipient of such funds, taking into account factors including relative to the cost of living of the state, compensation levels for comparable state, local governmental employees, and size for the organization that administer federal programs including ETA programs. See Public Law 113-235, Division G, Title 1, Section 105, Training and Employment Guideline Number 0506. Further clarification, Department of Gov Agencies Advisory Training and Employment Guidance Limit Number 0506. Alright, intellectual property rights. Pursuant to Title 2, Part 2913, to ensure the federal investment of the Department of Labor funds with its relevant impact and is possible to encourage innovation and development of the new learning materials, grantee will be required to license public all the grade with the support of the grant under Creative Commons Attribution Title 4.0 license, which must be the license under Creative Commons attribution license includes both new content created with grant funds and modifications made to pre-existing grant-owned content using grant funds. License allows subsequent use of the copy to distribute, transmit, adopted copyright. Work requires such users attributed to work in their manner specified by the grantor. Notice of the license should be affixed to the work. For general information, common Creative Commons attribution license, please visit Creative Commons Licenses by BY 4.0. Officers' instruction making work with the Creative Commons attributed license can be found at wikicreativecommons.org. Make your work register with Creative Commons license. Questions on Creative Commons attribution license apply, but specifically funding opportunities should be submitted with the ETA Grant Management Specialist site. Specified in Section 7, only work will develop the recipient in whole and part with the grant funds is required to be licensed with a Creative Commons attribution license. Pre-existing copyrighted license or purchased by the grantor with the third parties include modifications such materials remain to the subject intellectual property right with the grantees received under the terms of the particular license or purchase. In addition, work created by the grantee whose funds without grant funds do not fall with the Creative Commons attribution license requirement. The purpose of the Creative Commons license attribution license requirement is to ensure that the material that developed with the funds provided with these grants result with the work that can easily be reused and improved by others. When purchasing a license, consumable or reusable material with the grant is expected to respect all applicable federal laws, regulations, including pertaining to the copyright accessibility provisions of the Federal Rehabilitation Act. Separate over the Creative Commons attribution license to the public, the federal government reserves paid up on a non-exclusive and irrevocable license to produce and publish or otherwise use the end to authorize others for the federal purposes of the copyright. All products developed under the grant, including sub-award contract with the grant and sub-awards to with any of the rights for the copyright with the recipient and sub-recipient contract or contractor purchases ownership under award, including but not limited to curricular training models, technical assistance products, and any of the related materials such include but are not limited to the right to modify to distribute such products worldwide by any means electronically. Otherwise, the grant may not use the federal funds pay any royalty license for use of a copyrighted work or the cost of acquiring purchase of the copyright work and work where the department has the license or rights to free such use in such work. Revenues generated through selling products developed with the grant funds include intellectual property. The Department of Labor treats the revenues such as program income. Such program income is added to the grant and must be expended for all grant activities. If applicable, the following ETA disclaimer needs to be on all products developed in whole or in part of the grant funds. Workforce product was funded by the grants awarded with the U.S. Department of Labor and Employment and Training Administration. The product was created by the grantee does not necessarily reflect the official position of the U.S. Department of Labor. U.S. Department of Labor makes no guarantees, warranties, or assurance of any kind express or implied with respect to such information, including the information on linked sites, including but not limited to accuracy of the information and its completeness, timeliness, usefulness, adequacy, continued availability, and ownership of this product is copyrighted by the institution that created it. Credential transparency. For the department wishes to ensure the individuals employed with the educator training provided to have the access to the most complete, current, beneficial information about providers, programs, credential, competency for the support of the public and federal funds. To this end, the department requires the information about all of the credentials, but not limited to the diploma, the badges, the certifications, apprenticeship, the license for the degrees of all level types and competencies. Knowledge, skills, and ability developed and delivered through the use of the public federal funds made public accessible through the use of linked open data for the format support full transparency and operability such through the use of the credential transparency description language specification. ETA will provide specific guidance for the technical assistance of the data elements included with the published open data for the information about the credential provided with the credentials associated with the competency with the delivered mode, geographical coverage of the industry sector, occupation, and occupations for which credentials and developed related assessments and related accreditation or other quality assurance where appropriate costs and available outcomes. Use of grant funds and participant wages. Grant funds may not be used to directly pay wages of the apprentices. On-job learning applied with the Category 1 for the equitable registered apprenticeship pathways partnership through the pre-apprenticeship to registered apprenticeship program. Enrollment in Category 2 creating education system aligned with the pre-apprenticeship program and registered apprenticeship program. For the purpose of the grants award with the funding opportunity announcement may be viewed as a subsidized training education cost. Registered apprenticeship to enroll for the programs can include reimbursing employers for some extraordinary cost of the on-job learning. The grants awarded under this funding opportunity act negotiated reimbursement percentage may be as 50% of the participant hourly wage. However, the Department of Labor to encourage grant recipients to negotiate lower rates as variable rates as such as starting maximum level reimbursement rate, reducing subsidy of their own overtime, where possible to ensure the maximum number of registered apprenticeships will be served by the project. With the final grant recipients must develop the on-the-job learning contract discussed below. The contract process set ground rules for the on-the-job learning with the employer, assist in determining whether the employer is eligible to provide on-the-job learning opportunity. With the contract must include the federal required elements for the on-the-job learning agreement. However, the state, counties, and or municipalities can have additional on-the-job learning contract requirements. Contacts of the also outlined terms, conditioning the employer on-the-job learning provider agree to provide on-the-job learning experience. Contracts with the employer can be set up for a specific period of time, but not necessarily specify the individual trainings to whom they apply. This allows the employer to provide training more than one trainee. If the employer only has one position and plans a limited training experience to one employee, the contract must include the individual trainee's information. For these grant contracts must provide the employer it's reasonable for the documentation skills gained by registered apprenticeship during the training period. It should also include the description of the reimbursement level determined for guidance and federally required elements for the on-the-job learning, symbol templates. Other resources of the grant recipients may access the Employer Training Administration online technical assistance related on-job learning contract on workforcegps.gov or gps.org for the following web address: workforcegps.org, resource 2017-1201-11-19 on-job learning toolkit. Grant recipients technical training. Grant recipients are required to participate in all ATA training activities related with the grant orientation, financial management reporting, performance reporting, product dissemination, other technical assistance training as appropriate during the grant period. These sessions may occur via the conference calls, virtual events, or such webinars and in-person meetings. Our use of fund support of services and apprenticeships apply with the Category 1, ensuring an equitable registered apprenticeship pathway, partnership with the pre-apprenticeship leading with the registered apprenticeship enrollment in Category 2, creation of education system aligned with the pre-apprenticeship program and registered apprenticeship program. Applicants are given the leverage support for the Workforce Opportunity Act. Other funding available with the fund that is not otherwise available to grant recipients use up to 25% of the grant fund to provide support for the outline in Section 4B3C3-2, project design. Individuals who are participating in education training activity provided through the grant unit of the funding opportunity announcement. Supporting services for the training apprenticeship include but not limited to child care, long-term service support, linkage, community service, tool, working, clothing, equipment required for the training of the job, application fees, other the cost for the apprenticeship to be required, pre-employment training, transportation, travel to training, worksite with the housing, internet access, mental health counseling, substance use treatment, and other behavioral health services, reasonable accommodation and or cost related with the direct service professional and provide assistance, persons with a disability, legal assistance, educational testing, financial counseling, need-based payments, or emergency gas assistance, services especially geared at attracting and retaining unrepresented groups such as mentoring, support groups, and peer networking for the purpose of funding an opportunity announcement. Grant recipients may either the grant funds up to the percentage specified above to provide support services to only the individuals participating in the education training activity provided through the grant, only in one unable tables with such services through the other programs whose such services necessary the individual enable the individuals to participate in education trainings under the grant. Grant recipients may establish limits on the provision of support services or provide the sub-recipients with the authority to establish such limit. Include the maximum amount of the funding, maximum length of the time supports over the new available apprenticeship. Grant recipients must ensure that their use of the grant fund support services is consistent with their organization established written policy for the provision supportive services. Additionally, we encourage grant recipients to identify with other sources of funding on the support services, including through the co-enrolling in the Workforce Initiative Opportunity Act. Use of funds and for incentive with employers apply with the grant categories. For Category and Category 2 for the applicants for the 20% of the grant funds provide with a one-time incentive for the new employers, joint labor management organization, industry associations, and other partners include multi-employer partnership to directly fund new and expanding for registered apprenticeships and programs to the targeted industry in which they are servicing. For Category 3, applicants may use 50% of the grant funds to provide one-time incentive of the funds with the new employer of the Joint Labor Management Organization industry with the association and other partners, including the multiple employer partnership directly fund with the new expanding with the registered apprenticeship with the targeted industry in which they are serving the law, but give the incentive with the funds to support registered apprenticeship development and launch sustainability include registration, registered apprenticeship, and with the Department of Labor that's relevant to the state apprenticeship agency. Costs related to design start with the registered apprenticeship classroom education online training for apprentices. Extraordinary costs related with the on-job learning, including wage of the extraordinary cost of the employer calculated based on apprenticeship wage as well as based on the journey workers' time as a mentor for an apprenticeship with the on-job learning apply with only the Category 1 ensuring equitably registered apprenticeship pathway partnership with the pre-apprenticeship leading with registered apprenticeship enrollment in Category 2 creation of the education system aligned pre-apprenticeship and registered apprenticeship. Category 3 registered apprenticeship hubs cannot be used incentive payments for this purpose. The training the trainer costs or activity training supplied with the apprentice for the consultation with the department and or curricular development. The administrative is focused not only with expanding with the number of the programs apprenticeship, but also diversifying industry with the registered apprenticeship, with increasing access with the end to and completion of the registered apprenticeship and unrepresented with the population unserved communities. As the previously stated, allowable activity providing incentive funding for the employer to expand with the registered apprenticeship opportunity with the unrepresented population unserved communities. The applicant must integrate, embed DEI and principles above listed allowable to give the incentive of the funding of the registered apprenticeship development, launch, and sustainability. These incentive funds must be allowed for the goals of the funding opportunity announcement. Applicant must have the written policy proceed with the governing and awarding incentive funds for the incentive provides for the funding opportunity. The announcement must comply with the organizational policy for the procedure should include detailed process identification recipient, distribution management incentive funds to ensure the complete employer commitment are met. Further, grantees should also provide with the quarterly narrative reports to that department and all recipients incentive of the funding status activities related to use of incentive funds when feasible and itemize costs related to use of the incentive funds. Alright, please note the other elements of Title II CFR 200 Uniform Administration Requirement Costs, Principles, Audit Requirements of Federal Awards, and Title II CFR Part 2900 Department of Labor Supplement at Title II CFR Part 200, including a monitoring examination of the records apply to any entities that carry out federal awards or recipients, subrecipients, including for profit and organization. In addition, with the entity may not earn or keep any profit resulting from federal financial assistance. Alright, F, other submission requirements. Withdrawal application. You may withdraw applicant with a written notice of the grant officer anytime before the award is made.